Hi, welcome to another episode of Unlocking Medicare with your host, Tyrone Carr. Today we have a special guest, Sam Lebowski from Lebowski Law Firm out of Milford, Michigan. And so we asked our viewers and clients if you would send in some questions that you may have pertaining to elder law, estate planning. And so we had a number of clients that sent some questions in. So we sent them over to Sam to see if he could answer some of the questions and help our audience and our viewers, just because we know Medicare and wills and trusts are complex. And so we want to just help our viewers, our clients and people in the community just have a better understanding of what they should do. So I guess the question that I have would be, when is it the best time for someone to have a will, a trust? And can you explain, is it an age factor? Is it assets that they have? Is it health reasons? What would be the ideal time for someone to?
Of course, I wish I would know that exact ideal time. I wish, I had a crystal ball to be able to tell everybody's health situations, family situations, whatever that may be. But generally said, it's kind of a blanket statement. You should be looking into getting some type of estate planning if you have assets that you're concerned about passing to your loved ones, to your children, etc. Now, having said that, any person later in life is certainly going to be more interested in doing some estate planning than somebody who's younger. But having said that, there's often times where younger individuals, whether it be have health issues or they pass away young, and they need those type of estate plans. And there's really no crystal ball to tell what age is proper, but when you know that you have enough, you want to protect what you have, and whether it be you're concerned about some health issues, you want your affairs in order, or you just want to really be able to check that box on your list. Those would be the kind of things to look out for. Now, having said that, anybody above the age of 50, it doesn't hurt to at least have some simple documents in place. And when I say simple documents, I mean healthcare power of attorneys, financial power of attorneys, the bare bones with regards to estate planning. And that would probably be recommended, certainly if they're above 50, to start looking into some of those more basic estate planning tools, and not necessarily trust wills at that point, but to start that conversation and at least get some tools in the tool chest, as we say, should you ever need to use those in the future.
So if you have an individual that has, let's say they own a home and it's free and clear, and outside of that, that's their biggest asset, it's paid off, they have a kid or maybe a son, daughter, that their intentions are to pass that home, that property down to the children. Would that individual need a trust? Or a couple need a trust?
Not necessarily. It's somewhat of a loaded question, and I'll kind of segue to the viewer who had posted the question. I think it was Robert, and that's kind of the example you're speaking about here. Married couple, there's 2 children. They're adult children that have no spend-thrift issues, as we say. So ultimately, they're not concerned about any drug problems or any excessive spending that would negatively impact that child or that children's heirs. So as long as those aren't an issue, you're really looking at the base, bare bones estate planning, as Robert kind of mentioned there. I think one of his questions might have been whether or not a trust would be needed, similar to as you asked. But in those types of situations, a trust probably isn't needed, short of the client wanting to be overprotective to provide and ensure that safety net is in place for any grandchildren. I think Robert mentioned there might have been some grandchildren in that situation. And if that's the case, that would really be the only benefit to having a trust, short of just cleaning things up in general. Now, having said that, as a general statement, anybody is going to be really better off, per se, as a general statement, with a trust. But it's not necessary in every situation. So in that situation, like Robert explains, maybe a ladybird deed, some advisement on having beneficiaries properly listed, and some power of attorneys might be all that's needed. And a trust in those circumstances wouldn't be recommended, but that's also a case-by-case situation. Everybody knows their family, their children better than I do.
So maybe this is the person that you're referencing. So reading this particular client's question, it's a pretty lengthy one, and there's a lot of detail here. And for the viewers, for listening, if this is applicable to their current situation. So, is curious if of him and his wife, they need a full estate plan rather than just our simple will with the proper paperwork. Everything will be split equally between our children. He's 70, his wife is 67. They have about $4 million in assets, plus our house is paid off and has a worth of about $850,000. They have a 32-year-old son and a 36-year-old daughter. They both have done fairly well in their respective fields, and they have no debt. Their daughter has a new home, 30-year mortgage at 3% on a house with a value of $800,000 and a loan amount of $500,000. Their son rents. The two kids along famously have no concerns there, and at this point, their daughter and her husband have a newborn child. We want our children to be the inheritors of our estate. Our estate will be well below the inheritance tax limits. No family issues of any kind. Is there a compelling reason to have a lawyer draw up an estate plan for us? And I guess for the listeners that don't know, what is the tax limit? What is the threshold there?
So Michigan does not have an inheritance tax. Some states do have a state inheritance tax. Now the federal inheritance tax, the federal estate tax, is roughly $11.5 million per individual. So for a married couple, you get twice that number. So ultimately, a married couple can pass away with in excess of $20 million before you're having to be concerned about those taxes. In the inverse, for a single individual, it's about $11.5 million before you're having to worry about those. So it's very, very high. We all wish we had to worry about those issues and plan for those issues, but not many of us do, unfortunately. Now, in that scenario with the Robert, the individual who you had mentioned, whoever that was, I thought the example, and kind of to compare and contrast, if there's $800,000, my advice is going to be much different than if there's $4 million for a handful of different reasons. One being, if there's $4 million, you're likely going to want to do a trust not just for the benefit of putting one of your children in charge and having the safety net for any grandchildren or future beneficiaries after your kids, but also you're having to be concerned about marital issues with your daughter. If there's a daughter, and I think there was in that scenario, if my daughter's going to inherit $2 million, she's in a new marriage, I would like to set something up that would protect her, that would allow her to keep funds in trust for her benefit, rather than commingling them with her spouse, ultimately being able to protect those assets to a certain degree should there be a divorce or other type of creditor issues like that from her spouse, etc. So that will certainly change my advice if there's more funds to protect, more funds to shelter going forward. But if there is, $800,000 in that same exact situation, a trust might not be necessary. Exactly what they're saying should be in place. Some simple wills, a ladybird deed for the property, and some power of attorneys with really some advice in ensuring that they have those two adult kids as beneficiaries of the various assets. So ultimately they will transfer to them with some further understanding of what they would need to do should one of their children pass away. Now that's not necessarily the best method, but that will certainly put the tools in the tool chest for them should they ever need to use them, and hopefully will give them a little peace of mind.
Okay. So next question from Bob. Should my spouse and I have power of attorney on each other? Question. And currently our son has power of attorney.
So the one question I would ask the person who posted that was, does their son have power of attorney over them, or just have a general power of attorney for himself? Now, two things. If he has a power of attorney himself and they're curious of whether they should get those for them, I would certainly recommend it. And it's nice that their son has done something proactive like that and got some power of attorney documents. Now having said that, for each other, if they're doing power of attorneys as a married couple, short of any capacity issues or other cognitive issues that may be looming, we would certainly name the spouses as each other's primary agent, while generally having the child or that other individual as a secondary agent, only to be able to act in the event that the spouse is incapacitated or unable to make that decision for the other.
Okay. Is there at any point a reason why someone shouldn't have power of attorney versus a person or a family, a couple that should have a power of attorney? Is there
no, not necessarily. With a power of attorney, notwithstanding the family circumstances, which is a little bit different from a will, and I'll go through that in a second. A power of attorney, notwithstanding the family circumstances, an only child, there's joint bank accounts, or there's no money, power of attorneys are always going to be recommended for individuals who are getting later in life, because the real reason, if they're ever deemed unable to make a financial decision or a medical decision for themselves, the nursing home, the hospital, or the doctor's office is almost going to pigeonhole them. They're almost going to force them to go through those guardianship and conservatorship proceedings, which are avoidable if you have those base power of attorney documents. Now, there's no way to avoid that. A little bit different than when we're talking about a will. If we're talking about a will, and there's a gentleman that has one piece of property, and he has one bank account, and that bank account that he has is joint and always has been jointly held with his daughter, we would do a ladybird deed, and I would tell him that I would love to charge him the money to do a will, but it's ultimately not going to do anything for him, because nothing will go through probate, and it will change nothing from what already exists under the default laws of Michigan, which say that your child, if living in a single individual, your child would get the assets. So in those circumstances, when you have simplistic assets, simplistic family situations and family trees, you can certainly deviate and not do certain estate planning documents such as a will or a trust, but with the power of attorneys, there's not that kind of out per se.
Okay. Do you have a itemized list, or where someone could say, well, this is where I can answer these specific questions. This would tell me this is where I need a will versus, a trust. We haven't talked about specific types of trust because there's different variations, right? But is there a process where someone can just say, let me answer these questions, and this would help me to identify if they weren't some clients say, hey, I want to reach out to Lebowski Law Firm and have a conversation. Maybe they want to, answer these questions first and then engage in a conversation. Is there...
not necessarily something like that you can put your thumb on. We have general informational sheets that go through kind of an itemization of what their assets are, what their family tree is, what their grandbabies' ages are, should there be any, so on and so forth. And combined with that and a conversation that we would have with the clients, we would be able to kind of identify whether or not that's needed. And understand that what I advise, clients don't always do.
Sure.
I just advise that if I think a trust is necessary, the client somewhat in a tough month per se, they might not want to spend that extra money. The thing about estate planning, it's discretionary.
Yeah.
People don't have to do it, short of them really needing it. And when they really need it, they generally have the funds, the discretionary funds, to spend to put those things in place.
Now, is there, here in the state of Michigan, it's a 5-year look back. So if you could expound upon...
We're talking about Medicaid look backs.
So if a person is, let's say, of Medicare age, and they have also, let's say their health has taken a turn for the worse, and is there anything that a person can do if they have assets, they don't have a trust, they don't even have a will, let's just say, for example, is there anything that person can do if all of a sudden they come to the realization, wow, I should have, maybe they're procrastinating and putting together or getting a trust. Is there a point in time where there's nothing you can do once you hit that stage and now you're in a nursing home or assisted living? Does that make sense?
The kind of point of no return is really when you have none of those documents and you're without competency. You've been declared incompetent. You can't sign your name. You don't understand your faculties, what your children's names are, so on and so forth. Really, in that position. In that position, unfortunately, if that's the case, you're stuck back at the processes we ultimately intended to avoid, which is probate court, guardianships, conservatorships, all through the courts. That's avoidable by having simple power of attorney documents. Now, if those simple power of attorney documents are in place, and those tools are in the tool chest, as we say, For a single individual, if they're looking at some situation like that, they haven't purchased long-term care from somebody like yourself, they don't have a good financial upbringing, they don't have a good financial advisor or a good person who's led them to a comfortable retirement, and they're in a few $100,000, say, in a situation like that for a single individual, the best that Michigan law will allow us to do, if they're needing a nursing home, we would be able to preserve half of what they have. Now that's taking advantage of all of the laws that Michigan has. On the flip side, for a married individual, the laws are very liberal. They'll allow you to preserve roughly about 90% of the assets while doing the proper Medicaid planning. Now this is meaning one of the spouses is needing a nursing home. And we're talking $10,000, $12,000 a month in nursing home, not assisted living, not independent living, the most intensive 24/7 daily care. And those are the avenues, as we say, applying for Medicaid. And where that comes in is there's the 5-year look back for Medicaid. So if anybody is ever in that position and they can't pay for that care, they go to Medicaid to pay for that nursing home bill. Now, if they have funds that can pay for that bill themselves, that's when they would see us to see what they can do to preserve what they currently have while also getting on Medicaid at some point in the future. Ultimately, if someone's in that position, whether they do that type of planning or not, they're going to be in the position at the end of the day to where they're needing to apply for Medicaid. So generally, it's advised, for these individuals who work so long and hard for their funds, is to preserve some for their family, whatever that situation may be, while also getting on Medicaid at the same time.
Okay. So here's a question from Pat. She was diagnosed with cancer in 2009. At that time, she was 62 and applied for Social Security. She started receiving Social Security. At that time, I didn't know I could have taken Social Security disability, which I would have received more money. I continued to work part-time at this time. In 2017, I got stage 4 breast cancer. I can no longer work part-time. I was working during tax season with HRB. 2 years ago, I was diagnosed with congestive heart failure. I can no longer work at all. Can I get Social Security disability now? I was just wondering.
How old was she again?
So she was, at the time she was 62, until 7, yeah, so she's of Medicare age. So in 2009 she had cancer and she was 62, applied for Social Security.
So if that's the case, you're going to be over 70 now. You're going to be better off taking the higher benefit, which is going to be regular Social Security, from what I've understood.
Okay.
The disability is only going to be more if you're under retirement age, from what I've understood.
Okay. And then a question from Bruce. He has avoided making final plans because I am worried about the costs involved. Can I make my own will, advance directives in financial and healthcare without having to use a lawyer? What is the benefit of including legal advice? What is the expense?
For power of attorneys, wills, you certainly can get all those online. I know when you go to Staples, you see the little packets in there for $15, whatnot. We never like to advise that. Certainly it can work if you do it right and you pull the proper document, you get it witnessed properly, and there's no ambiguity within it. Those will work for the most part. But should there ever be any issues with the document, or should it not be executed properly in accordance with Michigan law, it won't be accepted and you'll be back at the same position you started, which is what you'd want to avoid. A general cost for some simple estate planning, about $1,000, give or take. Now if we're just doing a deed, sitting down with you, doing a deed, advising you on these beneficiaries, putting some power of attorneys in place, it'll be very, very nominal, probably a little bit less than that. Just putting those tools in the tool chest, I say, if you ever need to use them.
And is that something they can just reach out and maybe work something out with them that's within the framework of what they can afford?
Of course, yeah.
Okay.
And if that's ever the case, we'll always kind of prioritize what would be needed.
Okay.
And it seems like in those individual situations, it might just be the bare bones.
Yeah.
Some power of attorneys, ladybird deed, and some advisements on what to do with their other assets should they not already have done those with.
And I always suggest, I mean, there's a reason why you're an attorney. Using my space as an example, the Medicare side of things, Often you see people try to go and do their own research and do a deep dive into Medicare. They're reading all these different books, or I spoke to a peer or friend. But where do you know where to start? To have that foundation in place, and what information you may have gathered at that point in time, you may not have dove deep enough into it to really have established that foundation to where now it lays the groundwork for moving forward, and you could still end up with the wrong answer, or the wrong type of policy, which is you really don't know what you have until you need to use it, and then you go to use it and you don't have the proper coverage in place, and maybe you misunderstood the laws and the rules pertaining to what you read because it wasn't applicable completely to your situation, and the circumstances could be much different if you don't have the right information in front of you. So I find that to be true. So in giving legal advice, I would highly recommend talking to an attorney, and just be transparent. I think, we live in a world where people just aren't as trustworthy, and, the fear of maybe being vulnerable. And so I think I always try to come from a place of just grace and empathy, and not everybody's in the same financial position as the next person, and that you're not here to judge them, and you're just here to help. And I think that helps as well as far as so I would encourage anybody who's watching, listening to this, that just ask questions and just be transparent, because that's going to help you both come to a conclusion ultimately as far as moving forward. So what type of advice would you give someone, in identifying a good attorney versus, some of the experiences maybe that you've come across? You've reviewed other, legal documents that other attorneys have prepared. Is there some advice that you would recommend or give to somebody to be careful?
The advice without it being direct advice is go to somebody who specializes in this area of law. Somebody who deals solely with elder law issues, deals solely with estate planning issues. And sometimes I like to say I don't go to the chiropractor to go get my eye checked out, and that's kind of a good saying that holds true with this area as well. You don't want to go to an attorney who dabbles in estate planning to get your estate plan done. You want to go to somebody who specializes in that area.
Would you have you had experiences where that you could share someone that has a trust or a specific type of trust that wasn't prepared properly? Like, maybe, for example, you hear irrevocable trust, revocable trust, a special needs trust. Is there anything like that you would see that you would identify as the wrong type of trust for the wrong situation? It just wasn't applicable?
Maybe not necessarily on that point, but that they haven't been advised properly on how to fund that trust. The trust is similar to a garage that the contractors build. It's only good to the extent you put that car in the garage. Similar to the trust is only good to the extent you put those assets that you hold within that trust, or you have your assets with the trust as the beneficiary. So if you kind of leave that step out of it, the trust funding step, that's some of the most common mistakes, per se, that we'll see clients do. And I'm not even sure it's a mistake, misguidance from the attorney, or they've just changed assets so much throughout the years that it hasn't occurred. But that's one big thing that we see is general practitioners will do estate plans for clients, and they won't advise them properly on how to fund that trust or how to avoid probate fully, and they're ultimately back in the same position should something ever happen to them.
Okay. So I have this question from Linda. She has a 25-year-old son who is currently on Social Security disability. He has difficulty maintaining a job, little sense of time, responsibility really doesn't have any responsibility with money. As his mother, and she has the representative payee, she would like to know how we could set up something for him financially when his parents are gone. If he received an inheritance, how would he know how to manage it? Would like his inheritance to last for his lifetime, being that he's so young.
Yep.
If it were to be left to him, it would be gone quickly. So what would you recommend? They have a trust I spoke with her to get some more detailed information. About 5-6 years ago, it's a revocable trust. He just doesn't, he struggles with anxiety. So for him to keep a job, what would you recommend in this case? Because again, the biggest concern they have is just him inheriting the money and then just spending it. How would you recommend setting that up? And is a revocable trust, based upon what little information that I've shared with you, is that the right type of trust? Because you hear, again, the special needs trust. Your thoughts?
Right now, the revocable is the right trust to have, generally said, from what you're explaining. The special needs trust would really be in place should he be on SSI, he'd be on any income asset dependent state benefits, Medicaid, those types of benefits is when a special needs trust would be more and most proper, and that would only be used for after death. So it's nothing that would be funded immediately during mom's lifetime. It would only get assets after her death. Now that's the most extreme if there's ever any concerns about him possibly being on those types of state benefits, or if he currently is, the SSD would not qualify for that. But from the situation she's explaining, two things. She's going to need a trusted family member or third party to assist with managing that trust after their passing. And they're going to want to ensure that there's provisions in that trust that allow the trustee to hold funds in his or her discretion for the child's health, support, maintenance, education, buying of a first home, at the discretion of the trustee. And that's ultimately going to be a discretionary trust managed by that third party that would create that exact protection that she's speaking about.
Is there a specific type of third party that you would recommend?
A good trusted family member is the first place that I would advise to look towards. Aunt, uncle, somebody who you would naturally proceed to take care of that child should he or she been a minor.
So what if you don't have any siblings, or your siblings you're the youngest of the siblings and now they're older, they've passed? What would be your next recommendation at that point?
There's certainly people who don't have individuals who can manage those trusts, who are competent to manage those. There are professionals who can do those. We generally don't like to advise that because they charge, and family members won't charge. But in instances to where you're in that situation, certainly can turn towards professionals. We've seen people name their CPAs, so on and so forth, within these fiduciary positions and documents.
Okay. Would you, being in her case, and this is a question that I had, in her case, you have someone that's had a trust for 5 or 6 years. Is there a timeline that you would suggest someone having their trust reviewed, being that the state laws change and maybe a person has inherited some assets, so what they started out initially, 5, 6, 10 years ago, now their wealth has completely changed. And then also, how important is it for someone to make certain that all their assets, whether it be IRAs, whether it be Roths, whether it be a 401, as far as making certain that they're, the beneficiary is the trust? Because here's some people say, no, the beneficiary should be the trust, and some will say no. So your thoughts?
With the trust and not having the trust, what that generally predicates on is whether or not it's a retirement account in qualified funds. Now, if your trust has the proper provisions and the proper flow-through provisions, it's not going to make any difference at the end of the day, other than extra paperwork to complete and to go through. And what the real situation is with that is they want and they're preferring each child, each beneficiary, to be able to do as he or she pleases with those retirement funds, such as take it all out within the first year, leave it till the 9th or 10th year, and that's the Secure Act, which says that only spouses can inherit IRAs, 401ks, retirement funds, and stretch it based off their life expectancy. Anybody else is stuck with taking those funds throughout a 10-year period. So generally, clients will prefer to have their kids listed individually on those assets to make it a little bit easier for them to claim those and a little bit easier for them to take them out when that time comes. Now there's no right or wrong answer, so long as the trust has the proper provisions. They'll both allow those clients to do those types of maneuvers.
Okay. Anything that concludes our questions that we have at this time. Is there anything that you would add or suggest that would be questions that people should be asking, just general questions pertaining to legal advice, estate planning, they could share?
The importance of really identifying these issues, which seems like a handful of people identified these issues. A lot of them are on the right path. Do we need any trust? Do we need a will? And it seems like they've done all the proper things, such as having their kids as beneficiaries, identifying the issues that would spark different conversations, such as grandbabies, family fighting, so on and so forth. But as long as they're identifying those issues, every plan that we do is specifically tailored to the person, the client. There's not one stock price, there's not one stock document. Every document, every plan specific to each person and each person's budget, as you mentioned earlier.
Okay. Well, I appreciate you very much. I know it's the stuff that we see out there and experience, and it's so complex, and the laws and rules are ever changing. And so I appreciate you coming on and just sharing your wealth of knowledge that you have regarding
of course.
Estate planning. So,
and the last thing is, I kind of remember the question you had previous. If individuals are looking to get their documents reviewed, the main changes that we'll look at to change in those documents is the provisions that were applicable to the estate tax. The estate tax is now 11.5 million or so, but it was not that in 2000, 2005. It was a few million. So there's a lot of different trusts that were drafted back then that are no longer applicable for today's age and sometimes cause more headache than is necessary. So those are often provisions that will change within documents if somebody has a very old trust, just to clean it up to ensure that there's no headache upon the first to pass.
Okay. That leads me to a question that I have. So going back to Linda, her attorney that wrote up their trust has since retired. So it's been 5 or 6 years. How often will you, with your clients or just Lebowski Law Firm, how often do you review a client's trust? Is it necessary? So what would you recommend?
We'll recommend every 2 years. Every 2 years you come back in, we'll sit down with you at no charge, go through the different family circumstances, family changes. But if there are any family circumstances that change, obviously give us a call. But before that, and we would address those specific issues.
Okay.
At least every 2 years, and there's no right or wrong answer there. Some clients it's more frequent if they have more of a technical estate plan. Some people it's less frequent.
Yeah. Well, thanks, Sam, and the viewers. Thank you for watching another episode of Lucky Medicare with your host Tyrone Carr. If you like the video, please subscribe to the channel below. And look forward to our videos we'll be posting Monday, Wednesdays, and Fridays. Next week's special guest, we'll have 2 individuals, Carrie West from Care Patrol, to talk about nursing homes, assisted living facilities, and helping place our loved ones, parents, grandparents, or even kids, unfortunately. And then we'll have Chris Sadie from Affinity Home Health Care. So if you have questions regarding home health care, please stay tuned to those videos. And again, thank you for watching. Have a great day. Thank you for watching today's episode. If you're in the Metro Detroit area, visit our website for dates and times. We'll be hosting a Medicare workshop that you can come, listen. It's free, and we'll answer all your questions pertaining to Medicare. And again, thank you for watching this video, and make it a great day.